Eh, Hello, everyone. We have assembled here today to have a session by Manisha Ji Karia, which is organized by Committee on Commercial Laws, Economic Advisory, NPO Cooperatives of ICAI. Before we start the session, let me give a brief introduction about what exactly this committee is doing. So, this committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value, while also combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish technical guidance, background materials, etc., and more importantly, to create awareness for professional opportunities for chartered accountants in this area of commercial laws, economic advisory, and NPO cooperatives. Today, our eminent speaker, Manish Ashkaya, will be speaking on professional opportunities for CAs in mediation. And in this particular seminar, and we hope that this will be definitely useful to all the members today. So thank you, Manisha ji, for joining us today. But before we begin your session, I would love to introduce you to our participants. So please give me a moment to introduce you. So Manisha Ji Karia has been designated senior advocate by the Supreme Court of India. Before that, she had extensive practice before the Apex Court as an advocate and record and has regularly appeared as counsel before various judicial and quasi-judicial bodies. Additionally, she has established herself as a respected arbitrator and accredited mediator, bringing extensive experience and expertise to the field of mediation. She is empaneled as a senior mediator at the National Consumer Disputes Redressal Commission and with Singapore International Mediation Center, which is one of the most world-renowned centers, having successfully completed specialist mediator workshop at Singapore. She has also completed a course conducted by master trainers by Center for Effective Dispute Resolution, CEDR, and has been handling complex mediations for national and international clients. She is appointed by Bangladesh International Mediation Society as the ambassador and faculty. She has extensive experience of more than 2 decades in handling a broad range of complex, high value international as well as domestic disputes and has represented clients across diverse sectors. Her expertise spans across Supreme Court matters in varied sectors and areas of law, including just look at the range of the laws she has experienced constitutional, education, corporate commercial disputes, which involves insolvency, contract related issues, competition related issues, and companies, consumer protection, also service, employment, labor, property, insurance, taxation, intellectual property, criminal, and also international and domestic commercial arbitrations. She has been appointed as amicus curiae by the Honorable Supreme Court of India in several matters and has been on the panel of amicus and legal aid of the Supreme Court. At the forefront of legal issues, she has number of reported judgments to her credit, which involved and settled important questions of law. She has contributed to numerous publications by regularly writing on several topics in reputed legal portals and publications. She is a co-author of the chapter on India in electronic evidence published by the LexisNexis Butterworth publications. She has contributed chapter on law of conciliation in India in the book on conciliation and mediation in India published by Kluwer International. Her chapter on role of mediation in international dispute was published and appreciated by Africa India Mediation Association. She has regularly contributed articles in Flair Talk on significant public topics published by All India Reporter. Manisha, Manisha ji, today we are indeed very lucky to have you here. On this note, I'll just end your introduction by a very apt quote by Abraham Lincoln, which says that a good settlement is better than a good lawsuit. So we are definitely looking forward to your session here. So over to you now.
Yeah, thank you, Ruta, for such a lengthy introduction. In fact, I told my office to cut it short and give it to you people.
Ma'am, but I think it's really important. Really.
To apprise you that, the mediation is, apart from all my other work, what I've been doing, mediation has been very close to my heart. And that's something which I started after dropping out from the law firm and starting before in the Supreme Court. I think I was one of the first batches by CEDR to be trained in Delhi. So people from London used to come and train us here. That time, the mediation training in India was not that popular. So, but with your career growth, your other
True.
aspirations,
Because even we didn't know about mediation.
yeah. So mediation is something which everybody, like any common person can also pick up, and the dispute has been there with us in our society since we were born, or till we leave. We are surrounded by all disputes. So now, how we handle dispute, how we look at it, is very important. Now, when disputes is arising in, it may be in commercial field, it may be family matters, it may be any other area where you name it, the areas you mentioned of my specialization, everything is about the dispute. We lawyers are sustaining today as a professional because of the dispute. See, apart from that, I represent even ICAI before Delhi High Court as well as tribunal. So some of the CAs who may not like me, but it's my job, I do it. So basically, disciplinary some actions I represent ICAI. So in fact, our life quality is depend on how we look at even our professional capacity. I can say evolves or get better if we look at it for a solution, a resolution. So I know I have a lot of credential as a lawyer, but I always say that if there is any possibility or a dispute can be resolved, who can resolve it? It can be resolved by a mediation. So India overall has a history where we started, our legal system was such that panchayat used to sit, and even Ramayana, Mahabharata has an instances of mediation. So Krishna was one of the first mediator which we know from a history probably as a. So these are the this is the legacy we are carrying of a mediation. And when we look at the opportunities is really vast. Wherever you can really intervene and find. And in my experience for 25 years, I've been working with a lot of CAs also. I handle a lot of tax dispute. Believe me, guys, the confidence what clients have in CAs, they don't have in their lawyers. So the CAs are the most, people whom people trust. They give their all financial assets to you, and probably if they have to settle, they'll come back to you and they'll ask for your assistance or a guidance. So only being a mediator is not important, but what I'm going to discuss with you today is what all you can assist being trained as a mediator or having that mindset as a mediator. So mediation is a viable option, a cost effective option. Some like lawyers like us thinks that, oh, what if the matters are resolved, what are we going to do? But that's not the correct approach. So mediation advocacy is something which we are we need to teach in India. Now the law schools have introducing mediation as a one of the integral subject as a law course as well. And there are many corporate ventures which are training people for mediation. They're sending people for mediation training because in negotiations and conciliation and mediation goes in hand. Now, arbitration has been a popular mechanism for ADR, alternative dispute resolution, but it has become another costly affair. So now, when as a chartered accountants, parties come to you uh, for with any dispute, not only the tax related dispute, but if they're facing any other dispute and they're coming to you, maybe that has every dispute which corporates or any individual also has will have a financial implication. So they may come to CS for advice, and which is where you require a mediation training and an understanding of a mediation, which can holistically help to make them understand how they can go about their disputes. So now, let me share my screen with you, and then we can start discussing about actually what mediation. Is my screen visible?
Yeah, now it is.
Second. Sorry. Okay. How? Okay. Is it not full screen? What is it coming then? It is in half screen. Uh, what is visible on your screen?
Ma'am, will you please go down this and make it full screen?
1 second.
Enable editing first. Please make it enable editing. Yeah, and then you can.
Second. Probably I'll take. On my. Okay. Are you not able to see? 1 second.
Top of the page, enable editing, or maybe you can try down on the right side corner. There is one glass like thing. You can make it a slideshow also, so that it will automatically get to full screen. Yeah, and now please come to the right end corner, right side down corner. Uh, no, this has come to slide number right side. Yeah, right side down corner. Yeah, the one next to it. Fourth one next to it. Another one, next one. Next towards right. It's it's like glass-like feature. Yeah, the same one. Yeah, that's it. Yes, it's correct. Ma'am, you are on mute.
Yeah. Good.
Perfect.
Thank you. So I'm not that tech savvy.
Yes, yes, no problem, ma'am. Now it's perfect.
When we talk about the alternative dispute mechanism, the popular mechanism known as arbitration, which is so nowadays, it is a very effective method. It has become very popular in India. We have an act in place in arbitration. There are a lot of trainings, lot of, I am sure like once upon, I think in past even I had given one lecture on arbitration with you people, but now the what we are today looking as in one field is mediation and negotiation and conciliation. These three things actually goes in hand. When we're talking about the mediation, we need to, in fact, see, I'm not talking as a mediator, but see, there are like we will explore the option you to become a mediator, but at the same time, you to assist mediation process is also something which I really want to apprise you about. So when we are talking about the assisting in mediation is also very, very important and crucial. So for that, you need a very good mindset to resolve dispute. We need to go with an open mind when we are going for a mediation. Mediation has to be started with a clean slate, so that everybody, in your parties involved, also are ready to come forward for any negotiation and a viable solution. So the mediation's growth in India has been really not that great, but it's very slow. Uh, we are accepted this method as a court annex mediation more than the private mediation. Now, because the trust factor is very important aspect in that. So as in now we have the act, we'll deal with the act also. The Mediation Act 2023 has come, and we, apart from that, we had certain legal provisions which like Civil Procedure Code, then Consumer Protection Act, Commercial Courts Act, which these are the statutes which already had, even before the act came in force, had certain provisions which encouraged mediation and gave an option to have a mediation. Now, for example, Commercial Court Act has a mandatory mediation in this process, which is where the role of CAs also comes in, because commercial dispute has lot of commercial transactions involved. There the parties need your assistance, and if you are, we have a trained mediators as chartered accountants. It helps to assess the complex commercial transaction which require a lot of tax issues also are involved in it. So maybe the benefit analysis can be done better and advised better in that scenario by a tax expert. So which is why this can be another forte to look at for this chartered accountants to train yourself as a mediator, get appointed as a mediator, or assist parties as a mediator. Institutionalization mediation is also has become a prominent in India, like from IIM and CAM. Mediation center are very popular in India, and they're doing good private mediations in India. Those, even every institution has their own set of rules. Even the court annex mediations which are happening with the court premises, which are like the matters referred by the court for any mediation, they're governed by their own set of rules framed by the respective high courts. So more popularly, we have Samadhan mediation in Delhi, with Delhi High Court, annexed to Delhi High Court, and that is really doing a good job. Even a Bangalore mediation center next to the High Court is also doing a very good job. Largely, people are now, like, I may have assisted many parties in pre-litigation mediation is also evolving concept. So those are the aspects in commercial. Suppose any breach of contract is there, and parties, before going to filing a suit, because the suit is going to take a longer time than even the arbitration, before even that, parties are going for the pre-litigation mediation, which has been suggested. Even if parties have filed cases in the court, even arbitration has been initiated, the mediation is still possible. There's a provision called mid-arm. So this started with the Singapore Convention, and Singapore's SIMC, Singapore Mediation Center, had first time it's in their rules. But now the lot of institutions in India also have adopted this concept. If you invoke arbitration, you go for arbitration, and the parties are advised or asked, because it's a voluntary process. We cannot force a party to come for a mediation unless they are willing to. So which is where the chartered accountants' roles or the lawyer roles come, who are advising parties in particular disputes or particular transaction, that how they can resolve. So their mediation is a mechanism which we need to be encouraged by all of us as a professionals. So parties opt for that option, which is very important, because otherwise, unless they're advised properly and made aware about the entire process, because the confidentiality, voluntary process, and the flexible process, it's a very informal process. Mediation is a very informal process. So since some institutions have their rules, people prefer to go via those institutions than the private mediations. And again, the private mediations are getting popular across the world. But in India, it may take some time, because we do believe in a certain straitjacket formula, the legal system. And now the India is also signatory to the Convention of Singapore Mediation Convention. So that also has given a lot of recognition to India for going for growth of mediation, along with the act coming in now. You will be surprised that Hong Kong was the first country who had the act, and then the Nepal is the second one who has the Mediation Act for now more than 10, 15 years. but the success rate is very low. Like, the awareness is the main part, which is where the professionals will play the role as to promote mediation when the new act actually boosts up the mediation process in India. So I've spoken to about it. High Court and district courts are having court annexes. Every district court and the High Court has a court annex mediation center, because see, when it comes to taxation, pre-litigation mediation, how far it is possible, the 2013 there was certain proposition by the government also for having mediation as an integral part of the system, but we've not been able to completely adopt it. So we'll be dealing with it later in the today's discussion. So institutionalization of mediation has played a vital role, because if you're going for a mediation and it is with any institution, then it has a more reliability. People do believe in the system and would have that different level of confidence in the process, because it's followed by certain rules. Institutional rules are something which every institution will have differently formulated. And now let's look at the mediation statistics, how mediation is developing. Mediation is primarily used as a, earlier it was like, the all matrimonial matters were referred, or mostly it was popular in domestic violence or restitution of conjugal right. The matrimonial matters were more popularly by court were referred, or even the mediation was possible in those cases, because we see where the globalization, the commercial transactions are more coming to for the mediation, because the fundamental rule is the relationships are not getting spoiled here. It's a time effect, like, it's a one-time solution. The parties' relationships are very important when we look at the commercial transaction. So mediation is something which can really protect you to come for a win. We have a win-win situation for both the parties in the mediation, because the mediation is to facilitate the parties to come for a mutual terms. The mediator role is also, we'll be talking about it. The mediator role is that we, as a mediator, tell people that these are the, like, benefit cost analysis we have to do. What are the benefits and pros and cons when you're going for a dispute, and what you need to achieve by resolving it. Because if we go for a litigation, it's a huge cost behind it, a time consuming process. So growth in mediation cases since 2011 has been really, you can see the data on the screen. We, like, gone high, like really high numbers, high case, lot of cases have been settled by way of mediation by now. Now, recently, even the Lok Adalats and all were arranged by the Supreme Court, where it's in another, it's not in mediation, but it's in another way of conciliation process, where if a trained mediator, lawyers who were trained as a mediator, whoever had participated in that, we saw the success rate was better. So we, as a, if you have a mediation as a fundamentally clear concept in your mind, you will be able to achieve dispute resolution. So that becomes very easy, where before even you are, like, you act as a mediator, then assist as a mediator. So these are the statutes which I mentioned, basically Consumer Protection Act, Commercial Courts Act. This is the legal framework, and Companies Act. Now we have a Mediation Act, then the institutional rule, even the NCLT, NCLAT still has a option when the parties reach up to that stage, the matter can be referred for the mediation. So it started with Section 89 of the CPC before even any other statutes were recognizing the mediation process in India. The court initiated this, and that converted to be a integral part of the CPC, and the ADR mechanism along with the mediation has seen a good result when, at any stage when the matter, before framing of the issues or at even the evidence stage, we have seen if the matter is referred to the mediation, the parties are resolving it. Even we've seen, as in Supreme Court, when the matter reaches up to Supreme Court, the parties are willing, if the matter is referred for the mediation, because they've spent number of years in the court, and now if the matter can be resolved by way of mediation, people are going ahead, and the good results are shown of the mediation, if the matters are referred to the mediation. Mediation Act 2023 has given a wide definition of mediation, which includes even the community mediation, even the pre-litigation mediation, online mediation has been defined under the Mediation Act, and are the slides going in your screen properly? There's no issue, no? Or
Right now it's Mediation Act 2023.
Right,
That's good.
so this enactment, like when we have enactment is going to of Mediation Act is going to be very, very useful, or probably people have that trust and faith in the process of mediation, which people used to be hesitant, people were not aware. But again, the mediation needs to be fully made aware. Who can make this awareness is the we professional. That's our duty now, to suggest parties for going for mediation and make them understand the process and the benefits of the same. So objective of the Mediation Act is to promote and facilitate mediation, especially institutional mediation, encourage resolution of the dispute via mainly commercial dispute and other dispute via mediation, enforcement of the mediation settlement agreement. Now, every time if we consider, there used to be in one question, whenever we have recommended any party, let's go for a mediation, the issue will be that how the mediation settlement agreement will be enforced. So there are certain, the Act gives us now the way out, how it can be enforced. Establishing a body of registration for the mediator. Now, whom do you recognize as a good mediator? They need to be registered somewhere as a mediator. People used to take trainings from different disciplines. Like, for example, I gave you my example. I was the first batch of ICDR, of a CDR, which where I took a training from. But then after, I was not approached by any parties for a private mediation because I was not recognized as such or registered with some organization. Now that SIMC has made an tie-up with Hyderabad Center of Arbitration. So they have a MOU with them. So international parties are also willing to go if the matter is referred after by court or by during the arbitration for a mediation. So these are the institutions which are recognizing where you will be registered, and even the Act provides for the registration of the mediator. Now, once you have a training, that 40 hours training you get from whichever institute, and then where do you register yourself? As a chartered accountant, you're registered with ICIA. But as a mediator, now you can register yourself under the Mediation Act and get recognized. And that's how, you can get to mediate more or suggest mediation through such institutions. Encourage community mediation is also main purpose of the Mediation Act. Now, we know a lot of community dispute also are resolved by way of an CAA conflict was there in the Delhi. We saw the Haryana border affected with the farmers' protest and all. There also Supreme Court had directed a mediation. So that is a type of community mediation. Then online mediation has started picking up post-COVID because it gave a lot of, during the COVID also, I recollect many matters we resolved through mediation, online mediation. Now this, it was like, the court hearings were going on, or even we were doing, all of us our work online. With mediation, everyone felt that you need a personal touch, one-to-one interaction. But no, there are platforms which are developed, which can conduct mediation very successfully on online as well. So that's been a very cost-effective method, again, to resolve dispute via mediation, online mediation. But for that also different skills are required. So proper training through an institution, which is very important and integral part of, to get it more success rate. The whole concept of mediation is a voluntary process, party centered negotiation. The voluntary process means what? It is not the court who can force, or it is not you and me as a professional who can tell parties to come forward. The process has to be very voluntary. The parties need to come forward. So probably we as a professionals can do is what? We can just explain them and encourage them to come forward and show them the brighter side if they go for a mediation, how things will be easy and what can be the benefits, and that of course the time, cost, and even the relationship. These three factors are very crucial in the any business transaction or any relationship also. So in that scenario, the voluntary process is something which you need to convince party to come forward for. They say that you can take the horse till the water, but you can't make the horse drink the water. So it's really a great skill required for any professional to convince party to go for that voluntary process of mediation. So since it's like, even if the acts, commercial court acts mandate it, I've seen the data where very few parties come forward and sit for a mediation. So once one case was filed against our client in Baroda, and the notice came for commercial courts. The notice came for a mediation. The client comes to me and tells me that, "Madam, ये तो mediation का है, हम तो करना ही नहीं चाहते, हमारे तो हम तो इसमें जीत ही जाएंगे." Now they have certain apprehensions, mindset. They're not जीतेंगे, पर when will we win the matter? When that matter will be resolved finally by the court? That also somebody needs to make them understand. So which is what, as a once you understand the concept of mediation, by a mediation training or making yourself understand how the mediation works, then probably we'll be able to convince the parties also, which is where the professional will take a vital role. It's again a party centered negotiation. So as a mediator, you have to be a neutral person. Once you go through a training, they'll first tell you, like, you cannot give your opinion, you cannot advise sitting as a mediator. If you're assisting mediation, yes, of course, as a chartered accountant, as a lawyer, as any other professional, you can advise your parties. But at the same time, when as a mediator, we have to be really a neutral person, and the parties has to negotiate and come to a conclusion. So it's a basically like that's why it's need a proper training you to be a mediator. So that I'll be telling you the institutions and the other opportunities and how you can get yourself recognized and registered as a mediator, and take a proper training also for the mediator. The informal process, there are no formal rules of evidence or any other procedure prescribed for the mediation. So understanding the psychology, understanding the dispute involved, one need to take that call on how one is going to go about that particular issue in the hand or the case in hand. Address legal as well as other underlying issues between the parties. Now, as a mediator, you need to, you can't tell them what they need to settle or what not, but understand what the parties want and then make them understand, probably just encourage them to come in between and to any mutual consensus, because both like when it is dispute, both the parties are at times very adamant. They would not want to, and the people advising them also are looking at their benefit, and every party's interest is involved. So it's a very fundamental issue to how the mediator can handle that, by not advising them or by not involving himself in any discussion, but the parties to be asked question, and then, oh, okay, if this is the solution, what can be the other way out to this situation? For example, there is any commercial breach of contract, and both parties are at loss, but they still want to blame each other. It's a lot of commercials are involved. So we need to tell them, like as in chartered account, probably you tell them that what is going to be the penalties if you don't pay this tax, if this is delayed, that is delayed. So all these things you can just discuss with the parties. Efficient, speedy, and less expensive remedy. So the mediation has been the most effective remedy if you see as a success rate in internationally, and the very complex matter also can be resolved easily by sitting together with the assistance of the parties because they know their interests better. It's a felicitative process where the mediator has to evaluate the dispute, aiming mutually to accept resolution, motivate parties to accept the resolution. Mediation proceedings are completely confidential. So what comes in a one room of mediation remains there. That even though it's a court annex mediation or it's a pre-litigation mediation, whatever we are discussing in the mediation remains in that mediation room, and the parties are open and free to go and ascertain their legal remedies outside, and nothing what has been discussed in the mediation can be used as evidence against each other or an allegation against each other. So these are simple fundamental rules of mediation process. Now, we're talking about the mediation and a pre-litigation mediation. Pre-litigation mediation is something which is getting very popular because many people are recommending that before going for any arbitration or even a lawsuit. Because once parties are convinced that they can sit together. Many a time, of course, both the parties, when there is a conflict, they try and negotiate, they try resolving amicably between themselves, but sometimes the situations are they cannot do it themselves. They need a neutral party person who can, facilitate that entire process. So, which is where the mediator's role comes, and the pre-litigation mediation are very cost effective. The Delhi High Court Samadhan Mediation Center has a proper form for it. We need to give a background of the matter, then what actually the parties want and what is feasible. And then the other parties called, if the parties gives consent, they sit together, the mediator assists them, and the matter can be resolved even before going for arbitration or a lawsuit. Now, the agreement which they arrived at is again, then now the act is in force, so that will be helpful. But the mediation center which you go to, that also the agreement will have certain clauses which also effectively need to be drafted, examined by the mediator. Once you go to the training, you will get that whole idea about how you can deal with those aspects. Now, there are stages of the mediation. Pre-mediation stage, then before the pre-mediation stage, the parties needs to be trained what they're going to do about this mediation. That's where the professional roles, even the mediator's role, which comes. Opening statement by the mediator is also very important part of it. Then the joint discussion between the parties, how the mediator handles or how the assisting advisors handles. Private, there are options given. Sometimes, the mediator can choose the way how they want to go about it. They can sit both the parties together and have a discussion, or they can discuss, if the parties are not willing to, then they can discuss separately with both of them, and the proposals can be given, and the negotiations further can happen between the parties. And then there comes the agreement stage where the professional roles is again important, and the post mediation process where the parties probably resolve their dispute and goes happily from the mediator. There are a lot of ethics which as a mediator need to be followed, because it's you need to be independent, impartial, and this is in section 52 also deals 15 also 15.2 deals with this in detail of the Mediation Act. Mediator must not manipulate the confidential information gained solely to arrive at any agreement settlement. So there are fundamental rules of mediation which we need to primarily set and then explain to the parties also and proceed further. There are duties assigned to the mediator. Mediation should be always have clear idea why she or her is calling for a caucus or any discussion, and explain the reasonable, the rationally behind that to the party. Why are we going for this discussion separately or jointly? So that becomes very easy process for the parties as well as the mediator. And as a mediator, you're the guardian of the entire process, because of course there's a dispute, which is why the parties are sitting in front of you. So that the how you handle them psychologically, or even methodologically, by understanding the body language or the nature of the dispute. Mediations are responsible to ensure safety of all the parties in any of the discussion. Their confidential information, there any damage should not be caused, because if they don't settle, they'll be going for the further litigation. Mediation must remain always a message has to go to the parties. The very clear message has to go in the parties. So we have to, as a mediator, very careful about the language used. We are not advising, we are not promoting, or we are not suggesting anybody or we cannot take any sides. So that's where the building credibility in the mediation process is very important. The problem-solving nature, those skills are very useful as a mediator. If you have a nature where, sometimes in a family, two siblings are there. One sibling will always come with a solution. The other one may just be little ideal. What you say, he doesn't want to compromise on anything. So where is the skill which has been beneficial? This problem solving skill is very beneficial as a mediator. Then the negotiating skill, balancing stakeholders' interests is very important. Right? When we talk about negotiation, we are not doing any as a mediator. You won't be, but if you're assisting the party, the negotiation skill is very important. Effective communication. These are the broader skills which every professional needs. But as a mediator, you really need to be a little trained and reading about and enhance your skills on these aspects. Then the analytical skill about how the parties approach are going to be the assessing financial implications of any transaction which is involved in the dispute. So probably come up with such solution that which both the parties are ready to maybe you cannot give suggestions, but you can lead them towards some solutions. What can be the role of chartered accountants in mediation? Now, ability to analyze any financial data is something which, most of the chartered accountant only have this skill, and other professionals are not really like lawyers who do not have any commerce background or any other details. Then it is very difficult for us to get into those integral part of commercial statements and financial data. So those are the complex matters where your expertise will be useful when such kind of matters come for the mediation. Now, corporate restructuring, in that also insolvency proceedings. Now, IBC has taken a different league in India. It is almost has become a money recovery mechanism. But yes, the corporate restructuring is happening very massively post-COVID and even pre-COVID, they were things. So that this kind of dispute always comes for mediation, and some in-between solutions can be worked out between the parties, between the financial creditors, lenders. So a lot of aspects where the chartered accountants are needed to help and guide, or even me as if there are chartered accountants, a trained mediator can help in this situation. Now, taxation compliances disputes. Obviously, you all are trained for that, but those disputes, how far, unfortunately, the Mediation Act doesn't, has a provision where it excludes taxation matters from the era of mediation. But at the same time, the settlement scheme, which is where your skills can be useful. Settlement, there are one time lot of schemes which government also keep coming up with. Financial statements, understanding of financial statements in the family dispute also is very important. If the chartered accountant is involved in the mediation process, it becomes very easy process to handle, because the chartered accountant can guide the families how their financial statements are going to be affected. Now, the corporate opportunities for CAs in mediation, mainly in corporate disputes, financial fraud cases, then real estate property disputes, family business disputes, where the structuring settlement is happening, tax dispute, mediation between tax authorities and the clients. That's not so accepted or popular in India, but I'm sure times to come, this is going to come one day or the other. Then the insolvency resolution process, as I earlier also said, there also chartered accountants have a lot of scope in involved being a mediator. Increasing in tax dispute has been now the CBDC had come up with the circular where the Supreme Court matter has to come. The low tax effect has shown us that above matter above 5 crore cannot come up to Supreme Court, and even the High Court has the limitation of 2 crores. So a lot of disputes are getting reduced, but at the same time, the existence, the multiple level of process as a chartered accountant also, where when the matter goes in a litigation, it takes a layers of process and a lot of forums you have to go through, and that delays the dispute, and that multiple transactions are involved. Sometimes because the dispute is there, the parties are not able to come to any expand their businesses. A lot of effect is happening on the business due to the tax issues pending before the courts for the longer time. So normal litigation mechanism, one matter, if the tax dispute goes into litigation, then it takes about, in my understanding, and even as per the data, it takes 10 to 15 minutes up to Supreme Court. I'm talking about. So that's why we need this mechanism and the mediation process to be, assessing officer, minimum 1 or 2 year nowhere. Then commission of income tax, CIT, there 3 to 4 years, or maybe it can go up to 6 to 8 years. Income tax appellate tribunal, 2 to 3 years easily, and the High Court, and then comes the Supreme Court. So what I said is, 15 to 20 years is nowhere. So in such situations, the mechanisms which were introduced, LDRP mechanism in India, how far it is been effective for international taxpayer that transaction, domestic taxpayers, advanced pricing agreement, mutual agreement, which is where also your mediation skill will be very helpful. Authority of even AR, before AR also, if you're trained mediator, you will be able to assist the parties very well in that scenario, how they can go about it. Dispute resolution panels, there, yes, the mediation training will really help. Settlement commission, again, I will tell you the settlement commission matter. I filed one matter which, the appeal against the Settlement Commission's matter lies only on the ground of principle of natural justice. Now, only on that ground also, if we go, the matter is pending for how many years? Something, one group is with me, Amrapali. The matter is pending before the Supreme Court for now. 2016, we have filed that appeal against the Settlement Commission order, and it is pending for last we are 2024, so it's almost more than 12 years. So we really need to understand, if I feel if the chartered accountants who are appearing before the Settlement Commission, if they are trained as a mediator, or even the officers who are trained as a mediators, they will be effectively able to settle the matter, because that mindset is needed, that with that training, that mindset comes for settling the issue. Then the different dispute resolution schemes are every now and then government is coming up with, which is where the mediators, as a chartered accountant, you can, and being a trained mediator, you can use your skills. Now, Vivad Se Vishwas, that was a one-time scheme, but again, that scheme could have been very helpful, and if more effective, if the more chartered accountants were trained as mediator. Because I remember a lot of people came back to us asking us as in lawyers as suggestions. How do we go about it? Is it going to be effective? Basically, when you're dealing with the tax issues. Now, see the dispute resolution panel. Again, we have this mechanism in place on our in our system, but then the faceless assessment mechanism, then dispute resolution committee DRC, which is where all this kind of disputes can be actually be handled very wisely if you're very well trained as a mediator or aware of how the parties can be convinced for this kind of settlements and these matters. Just 1 second. Let me just have a sip of water. Now, for legal considerations to play, for the mediation to be a successful in India, to resolve tax disputes and mitigating the extensive pendency of the tax appeal, it must be harmoniously mingled with existing principle of the tax statutes and underlining psychological barriers that exist between the taxpayers and the tax authorities in India. The tax authorities can strictly bound by Income Tax Act 1961, and therefore any agreement reached during the mediation, if any, will need to be fall within the ambit of that statutory framework which we have. The principles of legality has to be also followed in mediation, which is where the expert like chartered accountant can really play their vital role for this process via mediation. 6, to specific circumstances, emotions, interest of the parties, statutory framework will require all taxpayers in the same position to be treated similarly in a mediation. And principles of equality of the treatment is needed in this scenario. Now, when mediation may be very well utilized in India to prevent tax dispute from arising, but at the appeal from being filed from the first place, the same can also be done ensuring transparent interchange between dialogues between the taxpayers and the tax authorities. The lack on which one of the foremost reasons for the struggling rate of tax appeals in India is that in order to mitigate any psychological barrier and the lack of trust taxpayer in tax authority, post of the faceless assessment by tax official, the taxpayers can given the option to avail mediation with the tax authority. Now, unless that concept is developed and evolved, it is very difficult because there is a lot of confusion between in the taxpayer's mind and even the reservations as regard to the understanding the lot of process which is involved behind the you, the tax evaluation goes through. And the neutrality process of mediation is again something which can be helpful in this process. Now, what can be the benefit of mediation in taxation is reducing tax litigation is number one, and harmonizing the relationship between the parties and even the tax authorities, simplifying the communication, informed decision making. Since in advance, the decision can be taken by the even the authorities, and even the parties can actually strategically decide how they can advise on the basis of that. Now there are in UK, mediation in taxation matters is a very successful mechanism which has been developed in UK, but how far it is acceptable and will be successful in India is in hands of when the act is fully enforced and parties are participating and the advisors are advising them. In UK, they're using this mediation to even resolve both direct and indirect taxes. The system has shown remarkable results, especially in small and medium enterprises, which again an industry which suffers a lot if any dispute arises. Because the small industries get really affected because of any dispute, because they have a limited scope. The large industry may not make that much of difference if any dispute lasts for a longer time. So there are data which are notably 79% of the tax dispute involving SMEs were resolved within 120 days. And that landscape has been very successful in UK. The same model we can use in India. Resolve the dispute, direct or indirect taxes, both by mediation. We have a good mediation centers. The local adalats are very effective. So these are the methods which can be extended to resolve the tax dispute as well. Because as I said, mediation centers are attached to basically when you're after CIPRP, if the matter comes to High Court, this can also, since there is no other provision under the Income Tax Act where the matter can be referred to the mediation, but definitely the High Court can direct parties and even the income tax authorities to sit together and go for a mediation and resolve the dispute unless there is a substantial question of law otherwise involved. Because the fact-finding body is the last body is appellate tribunal. After that, it is very difficult to convince even. So that's why at the Lords at the beginning of the mediation dispute also, there's a need of introduction of the mediation in the process of starting at the AO levels. Because we have successfully largely commercial disputes are getting resolved by way of mediation. So how we can get this into tax dispute also can be resolved is something which need to be taken forward. And the mediation and conciliation committee in Supreme Court played a vital role. And the very same committee also can push taxation mediation and help reduction of tax cases. Now, this is a vital part. How you which trainings to be taken and what certification to be taken by the chartered accountant or any mediator who wants to practice as a mediator one of the profession. Like, you can do it along with your chartered accountancy. Some people do it as a, in times to come, it will become a full-time profession also with the act coming into place. So mediation specific skills are very important in, like, you as a trained chartered accountant, you're already aware of the financial side of it, mediation skill record, brutality, emotional intelligence, conflict resolution, and communication. These are the basics which I told you. These are the skills required, specific skill required, and most of us as a professional have those skills inbuilt in us. So taking further training, enhancing these skills will really help to be a good trained mediator. Now, legal work which is to be understood is the relevant institutional frameworks. Certain institutions will have their own different rules to how to initiate the process, what to be there in the contract, and what can be the fee structure of the mediation, etc. So every institute will have different framework. SIC has its own rule, ICC has its own mediation rule. Recently, we advised one party, which was an international contract, and that we suggested that instead of going first for the arbitration, go for a pre-litigation mediation because the arbitration cost was much higher. But then there was again, if you go for an arbitration and the matter is referred for the mediation by the arbitrator, you don't need to pay the ICC fees separately. So that's an integral part of that rule. So these are the benefits which you can understand by being attached to by taking a mediation training and reading about and taking any certification. This will help. Now, accreditation is something which is very important. Unless the registration under the Mediation Act starts, the accreditation for the international company, like, the corporates to believe you, and the accreditation is very important. A professional credential help establishing credibility to in the mediation field. Unless you are accredited with any other institution, any recognized institution of trained mediation, it is how do people trust you? You're a good mediator. Now, a lot of area centers have offering mediation training. So most of the high court in your respective states will have their mediation training, which is mainly, it's not only for the lawyers. Anyone, it's sometimes open for the many other people to also, the chartered accountants can apply for it and take any such trainings. Certification from the recognized bodies like ICA and Ministry of Law Justice. They're also offering regular basis training. You will have to be keeping a track of it. 40 hours training gives you certification that serves as a, then you can start mediating. You can get attached to many panels which are open, like now has a certain requirement. Commercial courts has their own panel. Consumer court has their own panel where the mediators are attached to the, the panel is prepared for as a mediators, and the court cases are assigned. Then SIMC is giving a very good training, which is you can take that specialized training. Once you go through the basic training, then enhancement trainings are also there, which can be taken. Now, even ICA has been, to my knowledge, has been organizing area certification courses. In that, the mediation also has been included as a part of it, and a lot of seminars. You can enhance your knowledge by attending them. Those role play exercises are very helpful. Unless, like, you're like many of us, as even if we are keen to go for a mediation, we've not had that experience in doing actual mediation. So in such scenario, if you take multiple different trainings or attend some enhancing courses, those role play exercises can help you to develop on your skills. Now, how those are, like, enhancing skill and knowing new methods and doing it again and again will only See, as a chartered accountant, we must have advised once, and then another client comes, we become an expert. The same way, mediation also follow the same thing. Party you assist, or one party you act as a mediator. The skills are developed with the practice only. So sometimes, if you're not getting to actually do any cases, then those role plays which are done in many short-term courses can help you to enhance your skills as a mediator. Now, the court annex mediation training are very popular. If you they can ICA can make the request, can have certain special slots for and tie-ups with the high court training sessions which are regularly happening. In that, certain CS can get regularly to participate as a to get training basically with the, so this is like getting those slots and to get the training from a proper center is also very important. Now, I told you about Delhi Mediation Center and even Bangalore Mediation Center. Both are extremely doing very well. And if anyone from those states are there, they can actually try taking trainings from these centers, because we find both these centers have very good trained mediators and good trainings are happening on a regular basis. Now, there are many government institutions which are also conducting the training, like Indian Institute of Corporate Affairs, National Institute of Financial Management, Ministry of Law and Justice, then Indian Institute of Arbitration and Mediation, IIM, Confederation of Indian Industry, Alternative Dispute Resolution, that their trainings also have really seen a very good. National Law School India, NLU, Bangalore also is having a course. Recently, I have heard National Law School Mumbai also have a MA in mediation. That's a 2-year course they are offering. So, I don't know how many of us, the professionals will have that much of time, but that's been conducted on weekends. So it's such an extensive course. I've seen the structure also of the course. We can actually, by taking such good training, enhance our skill and look for more opportunities as a professional in this mediation field. Now, international certifications. IMI is a globally recognized body, and they give accreditation to the mediator, but you need to have some basic training and then certain qualification. You can go on their website and see what are the requirements needed to get your certification from there, and the accreditation also, because they have certain rules to get you accredited and even to give you a training opportunity, and there are certain fees associated with it. The different institute will have different programs, the experience-based requirement, then assessment they do, then the certification happens in the accreditation. So all these processes you can go through and find more opportunity if you can get internationally certification and accreditation, which is very helpful, because I did my specialized training from SIMC and it really helped broaden my view about how I can go about any kind of a dispute. Rather, what training I had done way back in India and what I did in SIMC recently was very different. And the time gap, I could measure it because I was doing it, enhancing my enhancement course after a while. So it gives a different prospect. So taking up those small trainings or 2 days, 3 days trainings are very important, which will obviously you get to meet many more people who are like-minded and are actually practicing as a mediators. So that interaction also is very helpful. Now, this is again UK CEDR is one of the best, I feel, where you can get accredited and trained from. Certain fees are associated with it, but these are the, once you get those accreditation and certification, the commercial, since we are looking at the commercial dispute, most of the corporate will have trust in you and can come forward as your clients or come to you as a mediator also. And these are like, structured in different manners. Some are weekend courses, some are 5-day courses. So different courses are available, and these trainings are really extensive training. Like I've seen international training. If one is really keen on taking up mediation as a good professional opportunity, go for the SIMC or CEDR training. You'll find a huge difference in them. I'm sure, like, what our government is also doing, or what is our institutions are doing, are also really good. But in addition, if one is really keen on getting international recognition or practice regularly with the corporate in a mediation field, these are the two which are recommended courses, and the certification and accreditation. Like, we have Shriram Panchu, we have many other internationally recognized mediators in India. They've started from CEDR and SIMC, and they made their names. Now, Harvard Law School also has a negotiation program. That's also a very well structured program. It can be done from, weekend courses can be done. There are different structures which are available. One can go on the website, check how the course is structured and what suits your convenience. And those advanced courses also, they are again and again giving. So that those courses are also highly suitable. And, in high value dispute, chartered accountants are the most wanted mediators. I've seen that. So those, skills, you people are very differently skilled. You can actually take any good course in mediation and assist parties as well as be a mediator. Now, Singapore International Mediation Institute also has this 4-level course for the mediator. So just find out accreditation level and where and how, but entry level mediation courses are completely different. Then you require additional mediation experience. If you've done number of mediation, then they'll give you the second level. Then for the third and fourth level of mediation, which are required for the high value dispute, there are certain requirements you need to fulfill to get accredited or involved with or take up even those courses. So there are levels which you can achieve as in chartered accountant in the field of mediation. And since these are large commercial dispute, financial disputes, which are, in Asia Pacific region or across the globe, and being chartered accountant and expert in finance, you will be more sought for mediators if you take appropriate recognition and accreditation. So these are multifold opportunities which are available in domestically and internationally for the chartered accountants. But you need to choose your courses wisely. This is again International Academy of Mediators. Training and certification, then suitable for CAs with significant mediation experience looking for international mediators. Now, this you need to take a membership, and with the qualified worldwide mediators, you get access to if you are a member of IIM. So a lot of conferences keep happening of this, international centers who are giving accreditation. You get to interact with your peers and learn from their experiences. So this accreditations and certifications are very crucial if one want to really specialize and go deep into this mediation profession. And the techniques also you can develop by taking multiple different, because there are different format and formulas which everyone, it's a trial. Basically, there are different methods internationally. Some people use different skills and methods. So those you can only get by training and interacting or doing more and more mediations. American Arbitration Association also have a specific program for the mediation. So 40 hours training, then specialized training, advanced training, accreditation and membership. So more or less the structure works of most of your international and national organization in the same manner. So the more you go deep into it, you can take these opportunities and be specialized in some of them. Now, ICDI Young International, so young CAs can go for this kind of programs where the fee structure is less, the career opportunities are more there because I feel once we are an established professionals, you have more clients, less time on your hand. So this is better you as early as you start. So recognition and certification has its own benefit. The credibility is something which is very important. Once the recognition and certification is there and accreditation is there, obviously, even if we are a chartered accountants or lawyers as a professional, but if you have any additional recognition and this thing with a good institution, your opportunities will increase because high stake mediations requires corporate and financial matter required specialized people like chartered accountants, and even the cross border opportunities will increase. Institutional engagements will also come forward once this accreditation and certification happens. With formal accreditation, CAs can extend their practice into dispute resolution for corporate insolvency, commercial negotiation, and international arbitration. So your scope get really widened because there are so many experts also at times have been appointed in many arbitration proceedings where even the court proceedings. So there's a lot of scope if you are trained and accredited and certified. Now, new act, like the new act, the 2023 Mediation Act, the only act which we have is now opportunity as a member of Mediation Council also is there, because yet the the Mediation Council of India is going to be responsible for regulating and promoting the mediation, and this there's a certain criteria which you meet with. You can even be in part of this mediation council. There's another opportunity which with the enforcement of full enforcement of the act is going to come. Experts in mediations are going to be appointed in this council. Academic experts are going to be expected to join this. There's a representation of the mediation institutions, which is going to be recognized. If you're accredited with any of the Indian institutions, they might represent you to be a member of Mediation Council, and you can be part of this ADR and mediation promotion. The terms of the office is fixed 3 years, and they will be circulating. So if you are practicing more in the field of mediation, there's a likelihood that you get a chance here also. So now the online mediation, which is really improved post-COVID, this is very cost effective, and those who are very good with technology can handle and be this process by taking special training for the online mediation. And there are range of benefits which are attached to it, because you can, sitting in India, you can do anywhere in the world the mediation if you're appointed and getting an opportunity. Now, this online mediation has really expanded the services which we can globally give it to the clients and even the institutions with whom we are recognized. One is your cost is really effective in this. Specialization in niche areas like digital technology and commercial disputes are also coming up. A lot of dispute with development of technology have arisen. So those also are, they are also opting for a mediation, then going for any court proceedings. Efficiency and flexibility, because faster resolution process is involved, so flexibility is in the process. Schedule of fees can be really managed. So these opportunities one can take for, by taking a special courses on online mediation and get an expertise in this. Now there's like really online mediation is getting increased. Globally, the demand has increased on ODI platforms. Technological innovations in mediations have happened. Different platforms are coming up. People like, some startups I know where, they are putting there are a lot of efforts to develop that AI to uh, facilitate mediations. The court connection mediations are also happening online. Most of it, Supreme Court, we especially see it more often because all over India, the matters are coming to Supreme Court. The parties can't travel, so the online mediation is best way to reduce cost and time for the parties. There are like in-house mediation for the businesses and cross-border business disputes. So people are even looking to have trained mediators to be there in-house, employing them in-house, so that the any smaller dispute which are within the organization also can be resolved by way of a mediation. Now there are a lot of trainings which are like, today also we are online training, and certificate online mediation courses are available. This has this to, because sustainability will be another dispute resolution method. Like we, as I explained you in the last previous slides, UK has really achieved a lot on a taxation side to reduce litigation and the costs in a tax matters for by adopting a mediation method. The same way, if more people are trained and this becomes a acceptable method, then complex tax disputes can be resolved by way of a mediation. The mediation not a complete alternative to tax litigation, but it is rather an initial step towards the resolving tax dispute. So like we, as I said, it is very easy for the High Court to refer the matter for the mediation because there is like rule which says that you can go for a mediation, but at the same time, if it is introduced at the early stage, at the AO level or the CIT level, it will be more effective and more useful for the chartered accountants to be part of the system mediation and resolve the dispute. Pre-litigation tax mediation also, if it is a time has come, it will be coming soon in India as well. And you will, if you're a trained mediator, you will have the professional opportunities that those areas also. Litigation should be last choice and the mediation should be the first. That's what, in one times to come, this is going to be, if it is pursued and fundamentally looked at it and parties are encouraged, then all professionals can achieve this. The focus of the government department is also to make more awareness about the tax mediation should be there. The healthy relationship between the parties can be maintained, and even the government, like the authorities and the taxpayers can be maintained if this mediation becomes an integral part of the system. The increasing, we need that trust factor because the Income Tax Act has been sometimes been very harassing to people. In that scenario, people really want to give up and don't want to fight further and want to resolve in some manner. So this option at the regime is evolving. The transactions are going at a different level. the lot of development in the technology and the law and the tax regime can make a combined effort if you're good trained mediators and the as a chartered accountant who are involved, this mediation can take us to a different level. So today, if you're taking this as a one part along with your regular practice, you are trained, you will in future times to come, there are multiple opportunities which will be available, as I told you, where all you can take your training from. So I hope this gives you a lot of insight to where you can take your training from, how you can use your special skills as a chartered accountant, and where all you can find an opportunity. So if any questions, please, the forum is open. You can open the questions.
Yes, madam, it was really a wonderful session as usual, I would say. But there are a few questions. So,
Yeah, go ahead.
yeah, especially relating to many people have asked at the start that how can we explore these opportunities? Training, all right, but after we get the training, because there are many people who have also completed the ADR course of ICAI, which is organized by ICAI. So they have this alternate dispute training, a kind of training which ICAI conducts. But how now they should proceed ahead? That is something they are looking out for. If you can give some tips as to how we can explore this opportunity more, or is it based on networking that we have to talk to people and to get such opportunities? How do we go about it?
Let me stop my screen, or I just.
Yeah. Okay.
Yeah.
Yeah.
So, see, opportunities are going to come, and in my personal opinion, nothing goes waste. So that's like
Yeah. True.
I personally I took a training in 2006, and I was also very shocked. Yeah, I paid so much, and that time it was very expensive. And then too, we were doing it from the CEDR, and it's like there was no opportunity seen at that time. But slowly, the court annex mediation also increased so much. And now, if you are doing a private training from any of the government institution or any recognized institution, then getting empaneled with some of the other organizations as a mediator is very important. That is what will help you to get an better opportunity, because private mediations and like you to get as a that recognition as a private mediator will take years together, because even as a chartered accountant you have spent 5 years, 10 years, 15 years, and then you are recognized and people are coming to you with your trust factor. Because see, it's a and for people are scared also to come to the private mediators because of the confidentiality reason. There are many other reasons. Why do you believe individual? Yes, they believe you because you're registered with ICAI. So same way, if you're registered with some of the other organizations, the trust factor will be more. So I also got many opportunities when I got empaneled with organizations. So that empanelment opportunities you need to look for. Having only completing a training is not going to give you opportunities. So that being a accredited mediator, suppose I'm giving you example of SIMC. If you're accredited with them, you'll be attending their conferences, you'll be attending their enhancement trainings, etc. You'll be meeting the other people. So the same way, one client came to you, they referred you as a, like, they said, oh, this chartered accountant has given me benefit, my less tax I have paid because of this person. So same way, if the one matter you settle, the other matter will come. But accreditation and empanelment, somewhere or the other, it's to begin with is very important unless you become a recognized professional.
That is a very important tip that you have given, that we need to be empaneled also, because otherwise how there will not be any visibility also to people who want to connect to you.
Correct.
I think, yeah.
The accreditation and
Absolutely.
empanelment is very important. There are many, like Consumer Court has their own, NCLT, NCLAT has their empanelment. So chartered accounts are more needed in the financial sector. Even these MSMEs has their conciliation centers. There you need to get, like, see the opportunities where you can get an empanelment. So one or two empanelment once you have, then people start recognizing you. They start having trust in you.
Okay. Ma'am, there are two or three questions related to this particular case. I think we have answered it. Another question is related. I'll just read out the question. How has Government of India or Supreme Court incentivized adoption of mediation by, say, excluding conciliation outcomes from further legal review? CVC, CBI, ED, etc. I think I have not got the question, but maybe you have.
Uh,
I'll repeat it. I'll repeat it.
Question, because what
Yeah.
the person, I think, if that same person can correct if I've understood it rightly.
Yeah.
Like, they different schemes which are introduced. How that is going to benefit the trained mediators is something which he wants to know, or what the opportunities.
No, it is not about opportunities. This is how government or Supreme Court incentivized adoption of mediation,
Hmm.
but by excluding conciliation outcomes from further legal review.
Hmm. The people.
So, conciliation, whether there is a difference between conciliation and mediation.
Definitely. Conciliation,
Yeah.
something which, where a different process is followed. And the mediation is a voluntary process. Conciliation can be directed, and it is a part of Conciliation Arbitration Conciliation Act as well. But whereas the mediation is a completely party's choice whether they want to go for the mediation or not. Suppose one party is agreeing for a mediation, other is not, you cannot go ahead. But whereas conciliation or arbitration, whether the parties agree or not, one has to go for it. If it is there in your agreement, or if it has been directed by any of the authorities or the court, or if it is in any statutory requirement provides for that. So that's the difference. So mediation is completely voluntary, which is why I'm saying that we need a training and a awareness amongst the parties, amongst the advisors, even the lawyers, chartered accountants, or any other professionals who are involved in that dispute. They need to suggest them, you need to go for a mediation. So this is an easier or a cost-effective method for you to resolve the dispute, and time-effective method. Unless they're aware, that's what by and large I say, most of the people are not aware of this process. The general public at large, now as professionals, we are taking trainings, we are reading about the laws and the new developments, so we are aware of it. But your clients, your public at large, or maybe your some of your family members also would not know about it. So that awareness campaigning is more important now, that maybe some part of this mediation process is introduced at school level as well, because it's not only the tax dispute or commercial dispute or anything. The two friends are fighting, two relatives are fighting, everywhere this meet, like the mother, as a mother we do between two children, we act as a mediator. So this is a very simple and very what you call easy method to resolve dispute if it is accepted well. If not, then it is just not possible. That's why conciliation and arbitration is a completely statutory guided procedure. Here it's a parties voluntarily agree for the process, and then they go for mediation. I hope I've answered the question. If the question is not
Yeah.
answered, the,
So,
the
please, Mr. Subramaniam Iyer, if you feel that this question is not yet answered, please send a follow-up question so that we can answer. He has also asked about examples of prominent cases where mediation was successfully adopted. So, if you can give maybe one or two cases, and a question from me also. You had said in the presentation that we have to look out for non-verbal communication also. So maybe you can share with us some interesting case also.
yeah. So I'll tell you a property dispute. This is still going on, but the court, we requested, it's a matter came up to Supreme Court, two brothers fighting for a property. Now, one wants certain portion, the other wants certain portion. Both needs to be equally divided, but they're not able to come to an agreement. Now, how do you deal with it? The court tried, they appointed some local commissioner, still the matter has not been resolved. But the one good skilled mediator, how it would have handled is like, they may would have given certain dimensions, certain different levels. If you're sitting in front of the neutral person, a mediator can understand or put question and ask, what do you want, what exactly, where do you want to how do you want to resolve this. Now when the party is not willing to come forward, maybe the other side can come up with different solution that may be convincing. I'll give you the case where we are dealing now. The lawyer came and he was so good. He said, okay, this fields are adjacent to each other. Now they want to divide it this way. The commissioner also has given the report, but a good mediator has said, do it this way. Will it be okay for you both? So it was not a suggestion, but he just made them, looking at the map, made them understand, if you go this way, what is your benefit? You go the other way, what is going to be your benefit? So just from the part, feliciting the parties to understand their interests. If they keep fighting, how long they will take to resolve, or they may just lose, the property also. See, if one party wins, the other party has to lose. The mediation is something where both the parties win, and you save the cost, you save the time. So this is the clear example where the mediator only could make them, as a good mediator can only get them to this proposition that, look, on the map, where do you find yourself? So this was a classic example, one I find. The other is like, you need to sometimes be very neutral. You can't give your suggestions. So they expect you to give your suggestion. And if you give by mistake also your suggestion as a mediator, you're on a one side. That mistake, no one can do it. So if you are to have a successful mediation, then you need to, like, you see, even the Ramjan Bhumi was referred for a mediator and it could not get settled. And ultimately the court had to decide. Even the CAA matter was referred for the mediator, but the community disputes are by and large are very difficult to resolve by way of an mediation, or maybe like, we cannot at certain level, certain dispute cannot be resolved by mediation. So one has to understand, that's why the referral courts, the referring media, like the courts who are referring the matter for mediation, is also very plays a vital role. Like how they're directing it, what matter can go for a mediation is something which need to be identified and then referred for the mediation at appropriate stage. So I've seen the success rate is more when they are at the high court level or at the Supreme Court level, because the parties are tired litigating for 10 years or 15 years, and they just want some resolution. That's also one approach I've seen. But some parties are like, you need to look at, I've seen that if, educated class of people or a family dispute. Now, in one another property matter where we tried mediation and it got successfully resolved because both of them wanted certain things. So but they came to one conclusion, that maybe if I get the backyard, I can grow vegetables. The front portion, if someone gets, I will have this benefit. So you just have to make them realize the mediator role is that you can just ask them to discuss, ask them to give the proposals, and see how effectively you can handle that. The body language only, sometimes you have to get it. Oh, this is not working, stop them here. Otherwise, they land up fighting. People break down in mediation. They start crying or fighting, shouting. So one more case, it's not tax related, but or a, any financial transaction involved. This was a matrimonial dispute. And sometimes they're very sensitive. So DNA test was directed. This was somewhere in the news also. I was party to it, but the DNA test was directed by the court. Now, when it came to that, the parties came up to the Supreme Court. Now, both of them were so adamant. They wanted certain terms in the agreement, which is that the child is not mine or child is not hers. So, in that scenario, how the court also deals, the mediator also deals with it. So it was a very taskful, a skill for a mediator to convince this emotional background. So twice the girl banged the door and went out. So the lawyer assisting played a vital role. She explained, look, if everything goes in the court and because we don't disclose the party's name in such scenarios. So XYZ versus Y and Z has been given the titles so that the parties' names are not disclosed in this scenario. So she said, if anything, everything, if you fight out in the court, this will be the all in public. You have a child involved in the marriage. She came back and they sat down and they settle on certain terms. So we really need to understand what emotionally will play them. It's also very important.
I think that really explains that how things can be solved also once you understand the perspective of the other person.
Yeah. The interest of the person.
Right. Ma'am, another question is related to whether this mediation result, I mean solution, or once it is settled, then whether the outcome is to be registered somewhere in the courts or authorities for the sake of record or confirmation.
Which is why the institutional mediations are also preferred one. If the private mediation agreement, then we can have certain clauses which are to be drafted very properly, where it leaves a window open. If either party breach the terms of the agreement, the matter will be going back to the litigation or to the some contempt proceedings, or anything can other legal proceedings can be initiated if the parties are not complying, and what will be the implication of a non-compliance of each party. So that clause is very important. Depending on the situation and the dispute involved, one can draft such very wide important clause in the agreement, settlement agreement, and those are enforceable now under the Mediation Act also.
But that particular agreement that they have reached, settlement agreement, that needs to be registered somewhere.
No. See, it's a registration. If it's a court annex mediation, obviously it is via court. Once you settle, you submit, the mediation center where your mediation is getting, the mediation is happening. The center has their own set of rules and their clauses. And if it doesn't work, then one has to then you don't need any registration or anything. Anyways, there's no registration for this. So recognition via now the Mediation Act, under the Act also will be more than sufficient. We need to put the certain provision under the Mediation Act. We have settled this and we will be bound by this Mediation Act.
Next level is that, just a minute. Can you explain the concept of community mediation?
Now, community mediation will obviously in the community dispute. There are like villages which there is a fight between two communities, or even the cross-border dispute these days. So in that scenario, the two communities are made to sit together and the mediator are assisting them to resolve their dispute. I'll tell you an example where different sections of two society, low caste, upper caste, where they're mainly this kind of dispute nowadays you see in villages. So there was a huge dispute about the boundaries, or you can't come to our areas, you can't that. So in that scenario, the mediation can happen between two communities the way panchayatis used to do it earlier for us. So this community disputes are resolved in this way. So it's community dispute means a dispute between two communities which are involved.
So just a question from my side on this, that then who pays for this kind of resolution
Both
between
the parties,
communities?
both the parties, both the parties.
But
They
they come to, we
contribute.
need to give a court or something before the mediation process starts, or
This
to for any, not only in community mediation, but
either,
generally also.
either the party agrees, they go to any mediation center, they pay the processing fees. So now Samadhan Mediation Center, I'll just give you an example, which has a 30,000 as a processing fee. If your party, any party is applying for a pre-litigation mediation, they pay that fees, and by following the process and the form, the parties are called for the mediation. So if the other party comes, they will have their own rules to pay the fees, and both the parties pay for their expenses. And accordingly, the mediator will be also paid by the center, whichever he or she is attached.
Whatever standard processes of that center. So then in that case, these are the centers that you mentioned about where we need to get empaneled after we
Yeah,
complete the mediation.
after you have a training, see, every training may not be recognized. So suppose if you're from Pune, so Pune District Court will have their different trainings. If your Bombay High Court will have their own trainings, or even like if you need to be, and I think the consumer courts, so state commissions and etc., or even NCLTs, they have some recognition training or enhancement skill training. So you need to see what is needed. So once you are into this network, you will get to know what you need to do in your respective areas and where you enhance your or certify yourself and get attached to and get enrolled with.
Uh, the follow-up question on that conciliation and mediation was that actually the member wanted to understand about how the mediation itself is encouraged by the government or Supreme Court. That was a part, that was the actually question.
Now,
So,
if you see Vishwas se Vivad se Vishwas, so what was that scheme? So there are small schemes which governments are introducing. Even the settlement commission, for that matter, if you see the role which is being assigned to the settlement commissioner also, is something like someone like a mediator only. Both the parties are asked to come with their even the tax department or even the party involved in it, the assessee, both have to give the relevant document why this was missed from your this thing and what is the solution. So the government is introducing certain schemes where one-time opportunities are being given to parties to come forward and settle the dispute so that the litigation don't go ahead. So this time to time, certain schemes are being introduced and people are given that window of certain time frame where you come forward and submit yourself for resolution. Now, Lok Adalats are also the same way conducted. In recently Supreme Court had a huge Lok Adalat. So it was a kind of a, you can't call it a mediation, but the parties had to come and consent and settle the dispute amicably. So these are certain schemes which government time to time keep introducing to allow parties to resolve their dispute and get out of the long lasting litigation. There was some other question. It was something.
yeah, another question was related to, oh no, this is all right, that how government is encouraging
In the
mediation
Supreme
technique.
Court, you said how it is encouraging. So,
And
yeah, the
yeah,
most the dispute which can be recommended for the mediation by the court are specific dispute. So, if before going to the court, any matter can be mediated. But once you're in the court, there are certain criteria which you need to fit in. Those matters only, suppose criminal matter or a rape matter cannot be referred for the mediation. There are there are categories of matter which are specified, which can be referred. Matrimonial dispute, even the financial breach of contract, any other dispute which can go for a mediation. Now, once the notice is issued to the other party, the party has been asked, whether you want to go for a mediation and settle the matter. And most of the time, we've seen that if they are advised properly, they do go for a one mediation center, mediation session at least, and we've seen the good results. It's not like earlier. Now the parties are, most of the matters are getting resolved by way of a mediation. So that matter is referred to the respective state mediation center, or a Supreme Court also has its own mediation center.
Ma'am, then criminal matters definitely
The
would
other
not be.
encouragement which is there, at the initial stage, when the suit is filed and that's been referred to the mediation, you get your court fees back. At certain stages, if you like settle the matter, your court fees are refunded back. So I'll give you an example. I don't want to name the parties, but one IT company and one education institute, they had an agreement, and the matter went, like, initially also we tried settling, but it could not get settled. But before the evidence started, once again the court asked, because 7 years had passed by then, and the parties settled and they got 50% of the court fees back. So that's also good incentive which courts are giving.
I believe that will definitely help the parties to go for mediation rather than take court's time. I was saying that criminal matters are definitely excluded, okay, from mediation,
Correct.
as you rightly said.
The
Uh,
domestic violence, yes, those matters do go for the matrimonial matters. Though it's a domestic violence is not a purely criminal, it's a civil criminal, both remedy available under the act. Those matters are still because it's a family involved. So I'll tell you, 482
yeah.
any commercial fraud matters. Those are referred for mediations. Huh? I'll give you example. There are many matters which we have, 482 has been like question of complaint has been, someone has filed a fraud complaint. And the corporates only usually do that. Some contractor has not given the money back or anything. Then in that scenario, the complaints, criminal cases are filed. It's a easy way to put a pressure. It's a pressure tactic also, where you initiate a criminal action, and then the party come forward for the settlement. So when the complaint filed, they try to ignore it, but then other party goes for questioning, and then the court is referring matter for the mediation. The matters have been settled. Finally.
Okay, that's interesting.
The court cases I've seen that. Those are
Uh,
exempted.
so where do we refer such cases? Question was there that can you say some which journals or any resource is available where people can read about latest cases or case law, something like that?
Mediation is something is very confidential. So you will not find any records. So nothing can be in public once it's settled by a mediation. So it's only by
So
a
even without naming names, just
uh,
to understand the thoughts.
no, you will not find any records of any matter which has been settled via mediation, because the mediation agreement is signed between the parties. It even doesn't come to the court. It comes in the report to the court comes, matter is settled or not settled. That much report only comes. It is completely confidential between the parties. So actually, we cannot have that record. Or sometimes, if the parties have agreed for the terms, they get recorded in the order. These are the terms which we have settled at, and that's all. So more than that, nothing. That's why I said that mediation is the best process where confidentiality is maintained. Whatever you discuss, whatever you arrive at, or whatever you fight about, or there is no evidence, there is nothing. It's a very flexible process where you really can resolve in a different manner. Like you if you even if you see mediation room, they're structured, and many institutions have the mediation room in a manner that's a round table or oval table, where even the mediator is not sitting as a head, he's sitting as another party only, so that the parties are comfortable. So the opening statement which I mentioned, when you will be some of you must be trained, or some of you will take training, you will understand the opening statement is made that this is all is confidential here. I hope you both are coming willingly. There is no pressure. There is nothing which you will be forced to sign. It is completely your process. It's a party process which both the parties have to arrive at a conclusion. That's the very interesting side of the mediation, where the mediator only has to felicitate it and be a silent admirer of the parties there, and how you encourage them to come to a resolution.
So can it be in
Sorry, I lost your voice.
no, I said whether can it be in camera or recorded just for the sake of understanding that there is no coercion or something, or it is also not recorded.
And there's no coercion, because here you come by your own willingness, and if it is you feel there is a force, you can walk out. There's no penalty on it. It's very flexible process.
Okay. But in online, how it is? Online also mediation,
The
it is not
online
recorded.
platforms, see, Zoom also has developed certain features which really helps. The private mediation sessions,
Okay.
you can have you there are a lot of apps which are coming up, which are very suitable for mediation.
Okay. That's nice. Ma'am, last question about related to tier three cities. A person is asking about whether this opportunity to practice for big clients or cross-border transactions, which he is interested in. In such a case, how can he get such opportunities? I think, as you said, empanelment is one of the best ways to
Thing
go
is
for
like
it.
doing your certification from a good recognized international or a national institution, getting an accreditation, and then empanelment is something which will give you an opportunity. No matter which part of country or world you are in, you will be on their panel and you will get cases assigned.
Ma'am, how was your experience of Singapore?
The SIMC experience was really good. Like, not only me, Justice Kohli, Hima Kohli, who just retired as a Supreme Court judge last month, she also has done this course. Now they offer, they once or twice in a year they give it in Hyderabad as well. So you get an accreditation. If the SIMC people comes to India, they do the trainings here, and even that specialized mediation is training is by invitation, but yes, you can still apply and ask for the courts. There's one person who's in his name I'm not getting, he's an Indian work registrar, who's working there. Lot of Indians are working with SIMC, SIAC also. So you can get in touch with them. They're very approachable. You can get their free structure. Their course schedules are available, and the experience was fantastic. The kind of training I like, I had done 2 3 enhancement courses also in India after my CEDR course. CEDR was one of the best when I did it. Then when we did SINC, it was a very different experience. And as a like it was 2 days schedule. But out of that, maximum times we had this case based, we were giving different problems, and we've been made parties, we've been made mediators. Different role plays were played by us, and that really helped because I never got to do in a cross border dispute. But cross border dispute, as an example, to do in a SIMC as a role play was a very insightful experience. And maybe like next time when I get an opportunity to do a cross border dispute, because I as I I was connected to Bangladesh also, and when this
yes,
recent issue which
you
happened,
are ambassador for them.
yeah, so recent issue which happened, that time I would have got the opportunity, but it seems the mediation and all would not have worked. The situation was very critical. But in such scenarios, also one can get such good opportunity if you're connected with different networks.
The last thing, can we have your presentation?
Yes, yes,
Because many people are asking that,
definitely,
so that we'll share it. Yeah.
I'll share the information. And thank you everyone for.
Thank you, ma'am.
Hope my information was enough.
Yes, absolutely. Ma'am, there is no doubt that I've heard it now. I think I think thrice I've heard you before. So as usual, it is an excellent presentation, an excellent delivery. What I can say.
Yeah. Thank you.
Uh, online, there was the last question about online mediation, how confidentiality is ensured. Ma'am has already answered that there are various softwares that they are considered. Even Zoom has also a mediation related software where confidentiality can be mentioned. So I think that gets us to the end of the questions. Thank you, ma'am, once again. Yeah, you want to add something?
Some of the
Yeah.
private mediation, if they're happening, they do sign up the agreement that nothing will go beyond outside this room. So that also is an integral part of it, and nothing can be used. What is happening in the mediation outside the mediation if the matter is not settled. So it's very clear, fundamental, agreed principle, which and in the opening statement only the mediator gives, as well as there are terms which can be signed between the parties that we are sitting for a mediation, but nothing will be used against each other, or nothing what has been discussed here will go outside.
Thank you once again.
Thank
So
you,
looking
thank you,
forward to,
and
yes, more
it's
success.
good luck.
Thanks.
Okay, have a good night.
Thank you.